we actually have a very small change of plan today. We actually want to have Yan Luo to start by giving us an overview of the law in China before Sandra offer the comparative perspective. And then we will leave plenty of time for audience to raise questions. And if you have any questions now, feel free to put them in the Q&A box. Okay, so without further ado, let me first welcome Ms. Luo to give us the overview. You need to unmute first.
Hi, hi everyone. Good afternoon. Thanks for Angela to give the introduction, and it's a great pleasure to be here with everyone. So I understand today's topic will be really about extraterritorial effects of the the draft personal information protection law and other laws in China, and also how that's going to affect the cross-border data transfer. So, I mean, Sandra and I talked about it, and we will, definitely try to shed some light as far as that we know how this is going to be implemented in practice. But before that, I want you to start with an overview of what we're going to look like from the cybersecurity and data privacy perspective moving forward when, probably in a couple of months. So next slide, please. So we wanted to share, I wanted to especially mention that, when we are looking at the laws that should implicate cybersecurity, data privacy, data security, and all those topics, there's just not just one law, right? So we're going to have we're going to have 3 laws there. We're going to have the cybersecurity law, the data security law, which was just passed, and also we're going to have the personal information protection law, which might be coming very soon. So we can see that those 3 laws actually are each looking at the various kinds of risks from a different perspective, but then there's a lot of overlap between them. So and as we will see in the next slide, that that will impact how we consider all the risks and how we take a overview on how a company or a entity actually manage those risks. I wanted to mention one last thing before we move to the next slide is that, so if you look at, especially in the cross-border part, that there's a lot of other laws and sectorial rules which might be complicating which brings this as a pretty complicated picture, because it's not going to be that the horizontal rules established in those 3 laws we're going to sort of cover every aspect of it. Inevitably, there will be a lot of sectorial rules that will actually impacting companies' practices, especially in those highly regulated sectors such as financial services or healthcare sectors, where we already seeing or will likely to be seeing a lot of the sectorial rules that will be bring this picture a little bit more a lot more complicated. And also there's also other types of rules that of laws that might be from a different perspective impacting what we discuss as data security, cybersecurity, and privacy, such as the encryption law, and also to a less extent, export control laws. So all those things are likely gonna come up and bring this to a sort of complicated patchwork of laws and regulations. Even when we're gonna have the data security law and personal information protection, or PIPL. So with that, I wanted to go to the next slide and just mention how we view from a mostly from a global perspective and a multinational perspective, what are the risks involved here. Next slide, please. So as you can see that, again, sort of to matching the three laws that we have mentioned, we actually, this is a slide where we understand, how those are the risks are involved in, when we are talking about various laws and regulations, right? So we have national security law there. That's sort of, not something that most company would think about when they think about the, the cybersecurity or data privacy rules. But that's the important part of the Chinese legal framework, and that has been shown, especially been demonstrated by the recent, revision of the measures on cybersecurity review. So yeah, that's pretty much on people's mind right now. And more traditionally, we still have, consider cybersecurity risks that's arising from unauthorized activities, the hacking, the ransomware, and all sorts of, risks. And those are mostly addressed by the cybersecurity law. And finally, we will still have, a lot of discussion today probably will focus on the privacy risks, which is arising out of the, unauthorized data processing, right? So here we have the, the garden variety of, the privacy requirements, notice and consent, processing with a lawful basis, and so on and so forth. So that's really, if we think in a global context, that's probably for the most part addressed by laws, privacy laws like Europe's general data protection regulation, or the U.S. Various U.S. states laws like the California consumer protection privacy rules and stuff like that. So that's sort of the privacy laws. And in China, the second draft or the final PIPL is planning to is intended designated to address those risks. So with that, we wanted to so when we think about extraterritorial effect of the new laws, and when we think about how transfers, what kind of risks that the Chinese regulators might be looking at, addressing in those, requirements related to localization or transfers, cross-border data transfers, and we should think all three of them, right? So it's not just one risk; there are multiple risks here, and that companies unfortunately will have to sort of assess their own risk portfolios. The risk profiles each of those areas. So with that, I'd like to go to the next slide on more details of the rules. So I wanted to mention, because of, as you see, the title of today's presentation is about extraterritorial effect, and this is something that is probably new in this newer generation of the Chinese laws. If you look back of the cybersecurity law, which was promulgated in 2016, and that's sort of 5 years ago, the extraterritorial provisions actually are not explicit, right? So for the most part, the cybersecurity law has been saying that they only applies to infrastructures located in China or maintained or operated in China. So at least that's at the time, the regulators or legislators hasn't really taken a more aggressive approach in terms of the extraterritorial effect. But if you look at the draft personal information protection law, and just by the way, this provision hasn't been changed from the second draft, from the first draft to the second draft. So we also expect that will not be changed, at least not substantively, into the final draft. And this is a much more aggressive extraterritorial effects, extraterritorial provision, and that's a lot of that has been discussed, whether it's modeling, privacy laws like GDPR GDPR. So with that background, as you can see from the slides, this provision reads as that, this law will apply to the processing of personal information conducted outside of China, if the purpose of the processing is to provide products or services to individuals in China, to analyze or assess the behavior of individuals in China, or for other purposes required by the law, right? So that what that means, it means that if an entity is processing data, from personal, we say data subjects in China, or Chinese personal information, wherever it might be located, it will subject to this PIPL will applies to it. If you look at the wording of this terms, actually it's not that different from the EU's GDPR, which basically also established that if you're processing European data, then under certain circumstance it will apply. The GDPR will apply. So there's still a lot of question. For even under GDPR, for example, how do you mean by providing products or services targeting the individuals in one country or the other? For example, one of the questions we got a lot of times under GDPR is that if I'm a company, I'm having a website that is in English. Am I targeting EU citizens, right? So am I targeting, and therefore EU, GDPR applies to me, right? So this is a lot of the, when we were working with a lot of the Chinese companies, that's their question. Then, on the flip side, when China's PIPL is taking effect, we expect that there will be a lot of questions. What do you mean by provide the, products or services to individuals in China, right? So how about if I am a US vendor or US or EU vendor outside of China that contracts with a multinational that collects data in China, but therefore I'm only providing the service to the controller. I mean, if we say that for, borrowing the GDPR's term, for the controller that, processing Chinese data, but I have no other links with China and have no other linkage with the Chinese, individuals. Am I providing service or products to them, right? So those are the questions that will probably be addressed over time. And right now, this is all we have is what it has in the law itself, in the draft law itself. Another, I can already see some of the questions on the Q&A box, but we probably can address them a little bit later together. I'll ask Angela, if you want us to sort of address them while we go along. So I'll finish the slides by just mentioning that the second point on this draft BIPL's extraterritorial effect part is that offshore entities that process personal information of Chinese individuals shall establish a dedicated office, appoint a representative in China. So again, you can find similar setup under GDPR where someone should the controllers or that processing EU data will need to establish the representative in Europe, right? So this is actually a pretty burdensome clause for a lot of the companies that are not really having a lot of the business in Europe. So, but this is what PIPL is contemplating. Again, it's going to be a little bit tricky where if you are offshore, if a company is an offshore processor, right? So which again means that the company itself doesn't directly provide services or products to individuals in China, but they might be in touch of Chinese data because of their customers has those data, right? So and that will be that could be a complicated area that how do we want to what will be precise obligation of those companies that are offshore processors, which could be really a lot of them, and what the Chinese regulator plans to do with them, right? So those are the things that are we see the mechanism which sort of set the tone for how this PIPL will be applied extraterritorially. But there's a lot of detail to be worked out, and to and we will need a lot of further guidance from the regulator in the coming months, so we can sort of be more precise in terms of pinpoint how this is going to be imply what kind of impact the draft law will have. Next slide, please. So I understand, this is a part of the series of the presentation. So we are not, we're not going to go through all the PIPL, content here. But I just wanted to mention that there's a under PIPL, there's a lawful basis or legal basis for processing. Consent is one of them, but there's other consents like necessary to perform a contract, or necessary to comply with a legal responsibility obligation. So those are other non-consent based processing basis will actually brings a question later on, because if you're if the basis of collection itself is not consent, then whether as we see next, whether a company or an entity that is going to transfer those data out of China, whether they will need separate consent for transfer or not, that's actually going to be an issue again. One needs to have some clarification from the regulator. Next one, please. We will come to the 2 points here, 2 slides here, which I'll try to explain how we see the data localization requirements and also the data transfer requirements under both the draft PIPL and also the DSL, right? So if you look all of them together, think about what kind of company we have, and then what kind of obligations those companies will be facing when they are transferring different types of data out of China. Then that's those are the sort of the step-by-step determination that we come to, because it's actually quite complicated if you look at PIPL, and different companies might face different obligations, and also depending on what kind of data they're transferring, right? So we start with data localization requirements, but I wanted to mention here that again, we will probably need more guidance from the regulator as to how data localization requirements would interact with data transfer requirements, because if you think of data localization, there's a variety of ways that we can collectively call them as data localization, right? So a variety of infrastructure set up that we can say that. So there's there's you collect and process all the data in China, and without those in any of the data leaving China, which means that there's no access from outside of China, there's no transfer outside to any recipients outside of China, and there's no under any circumstance there's no data exchange between the system in China and then the system outside of China, right? So that could be one extreme of what we call as data localization. There could be other circumstances. For example, we have a local storage in China, like the data first route in China, and then transfer connected with with a server outside of China and then transfer the data outside of China for processing. There's also, do you want this, you have a simultaneous copy of data both in service in China and outside of China. So there's a variety of ways to say, what is data localization, right? So, and the law itself hasn't really provide any of the guidance yet. And also the law itself hasn't really provided guidance on, whether this is, what is the relationship between the localization and also the transfer, right? So it's almost like, you look at two separate sets of requirements, and we are not quite sure how this is going to be interplay as well. But hopefully we will have more guidance in the coming weeks, and in the coming months, but that's what we know now. So coming back to the data localization requirements, so if you look at it, we have actually started from the cybersecurity law. It has already mentioned that if a company is a critical information infrastructure operator, then personal information and important data, quote unquote important data that are collected in China will need to be localized, right? So hence you can see that, for CI operators, here we say to yes, right? So the red one is yes, which means that yes, those, the data localization requirements apply. But it gets much more complicated if a company takes a position that it is not a CI operator. Again, we don't have a clear definition of CI yet, so we are not having a definite list of CI operators. So it's mostly companies are saying, look, I'm taking the position I'm not a CI operator, based on reasonable assessment of its operation, its infrastructures, and the networks that it operates, right? So that's sort of, but that's the first step, right? If I'm a company that I'm comfortable saying that I'm not an CI operator, then when I look at the data I have, if I'm collecting personal information for the most part in my operation, then I'll have to look at the volume of the data that I'm processing, right? So if I'm processing a large amount of personal information, and this threshold will be specified by the Cyberspace Administration of China, then the requirement is yes, that it's potentially that I will need to localize, and that's the requirement. But if I'm not processing that amount of data, then it's possible that I will be able to transfer, and that brings us to the next slide. And the same thing goes to the important data, which is, as the data security law says, that if I'm transferring the important data, that will be subject to separate rules to be issued by CAC. So next slide, please. And that really goes to our next slide, which on the transfer part. Again, you can see quite similar stuff on the, on the first step is to determine whether I'm CI operator or not. It's not because that we wanted to sort of, think that, it's important by itself, but it's the way that the law is drafted that really, has different obligations on CI operators and non-CI operators. If we go through the same process, again, there might be that, if you're a CI operator, then if a transfer is necessary, then you have to submit, go through the security assessment by CAC, and same goes for important data, and also goes for the, large volume. So only when they transfer for the non-CI operator and also not in a large volume, then there's potential ways of doing the transfer by having by having the choosing one of the lawful mechanics, such as signing a standard contractual clause, which will be issued by CAC. So that's for the companies that are really not having sectorial requirements, those are the general process that we help our clients to think through what might be their transfer / data localization requirements that they might be facing. But for rules, for companies operating in, as I mentioned, highly regulated sectors, the chances might be that they will have a sectorial requirements that will override the general requirements. And it's really not quite clear how those sectorial rules will interact with the general principles set up by, for example, DSL, CSL, and also the PIPL. So that's that those two slides really introduce really the complicated framework that companies might be facing, in terms of considering its transfer or data localization requirements, and that's that's sort of the key points I wanted to present today. But we can just quickly go through the rest of the slides, and I'll I'll welcome Sandra's comments. Next slide, please. So as I mentioned, this slide is pretty much already explained by the two flow chart, and so I'm not gonna go through them in detail, but I wanted to mention very quickly on the important data part that given the recent developments, we do advise our clients to be more proactive, especially in terms of important data, because we don't have a definition of that, and we are still waiting for regulators, both at the central level and also at the sectorial level, and even potentially at the local level, to say what might be important data. So when facing those uncertainties in the next few months, we do advise our clients to be more proactive in considering the risks, national security risks involving cross-border transfer of important data, right? So we wanted to make sure that our clients really think about it, not just from the cybersecurity risk and privacy risk perspective, but also consider the national security risks. Next slide, please. I guess I'm not gonna, because I feel like enough.
We're slightly above over the time. So if you can speed up a bit,
so that's what I'm saying. I probably will leave this for very quickly going through the next few slides. So I just wanted to mention, like, there's some differences between GDPR and PIPL. There are things like lawful process for processing, how processing of publicly available information. There's some nuanced rules that might be different, although the framework, a lot of the concept is quite similar. So next slide, please. This is, I'll skip this one and the next one, please. Thanks. And the next one. So I'll finish the presentation. The next slide, please. I'll finish this with sort of, from a multinational perspective, how to operationalize those laws. And I'm sure, like, Sandra has a lot of, insights here as well. But there are a few examples, like, how do you consider to set up your program in China, including organizationally, do you want a DPO in China? Do you want to have someone else taking charge of that? And how do you see the cybersecurity risk, which is mostly manifested in the requirement to to get, you know, multi-level protection scheme certification, and also how to leverage the existing global program. So those are some of the, you know, thoughts that we have shared with our clients, and we don't have time today to go through them, but I hope that, you know, this you know, those the presentation can give you a high level overview on what companies might be facing and how we want to, you know, consider all the risks. Yeah.
Well, thank you so much, Yan. Well, I mean, given we are slightly running over time, so I will immediately move on to Sandra. So Sandra could start your presentation. I have tons of questions, but I will leave it at the end of the Q&A.
Thank you very much for the invitation, and I'm delighted to join Dr. Zhang and also Yang on this very interesting and important topic. First of all, can I go to the next slide? In order not to duplicate with what Yan has already touched upon, I hope that I can just focus on the key points and try to give you some comparisons and how does it work in terms of the difficulties and also the implication of these applications, extraterritoriality, and also when it comes to cross-border data transfer, and put it in actual context, and what as a multinational company can do to prepare ourselves. Before I move on to the next slide, I would like to allow me to make some a disclaimer here. I'm not in a position to give responses and comments on behalf of the group. So the comments and also the content here and observation are on my part only. So move on to the next slide, please. I understand that Yan has already touched on the big buckets and what it means under different laws. So I won't be present on a different perspective. So I just wish to comment that given the importance of data, whether personal or non-personal, to the success of the fourth industrial revolution, it is important that we're able to access quality and diverse data in sufficient quantities to inform our ideas, policies, and products, and to understand customers' needs. It stimulates economic growth and spur innovation. Data flow is paramount. Data protection issues and enforcement action appears in news headlines almost every week, and if not every day. It is not only a boardroom issue, but can become a tit and tat between countries as well. So it is important for corporates to understand and manage the regulatory risk carefully and strategically. And we have to bear in mind the policy drivers behind so that we can understand why the data model operates in this way. As mentioned in one policy paper released by a think tank in the EU, there are basically three broad types of data model. And the data model in mainland China is one of the three, which is described as a relatively controlled model that emphasizes on data classification and data and cybersecurity. Next slide, please. And in the interest of time, I won't be repeating the content on the three different laws, but I just wish to jump directly on the territorial scope of the PIPL and try to give you some context and also the comparison between the PIPL and also the GDPR. As pointed out in the slides and also in the above slide, the data protection regulatory regime in China is still evolving. And it's very difficult for companies to assess whether they or the third-party service provider have taken sufficient safeguards to ensure compliance. Due to the changing features, the actual data operation policies and practices are subject to constant review. Now, first and foremost, we need to understand whether and how the PIPL applies to the processing activities undertaken by companies. Apart from the processing activities that happen inside China, the PIPL extend the application to activities outside China under certain conditions. Now here you can see the text of the PIPL Article 3 as compared with the GDPR Article 3. But my advice and personal preference is look at the Chinese text rather than the English text, because a lot of times there would be a lot of the meaning and understanding will be lost in translation. So when it comes to the interpretation of the China law, I think for those who understand the language, it will be best to fall back on the Chinese text. The effect of the extraterritorial application provided by the draft law is undoubtedly one of the most concerned and widely discussed legislative highlights. You can see that it mirrors a lot and to a large extent to Article 3 of the GDPR. The problem of these provisions is conflict of laws, which will put firms or organizations in a rather difficult jurisdiction position with regards to processing activities beyond the border. The long arm of the jurisdiction may be at odds with international law principles concerning rule of reciprocity. And however, more can be observed to give necessary extraterritorial effect in the data legislation to ensure the protection of individual rights. GDPR is one example, and the Cloud Act is another. And some recent legislation, such as the POPIA of South Africa, PDPL of Egypt, and also the Personal Data Protection Bill of India, all contains provision on local processing, data processing carried out by overseas enterprises and entities. We must steer away from developing obstacle or jurisdictional disorder that hinders the development of global economy. We may find that data or network-based rules on extraterritoriality and extraterritorial application are to some extent inevitable in this, in light of the development of the data economy and globalization. Actually, the preamble to the PIPL, that is Article 2, specifically states the intent is to give extraterritorial effect in order to offer adequate protection to individuals within China. And if we go back to this particular slide and the text of this Article 3, apart from the processing activities that take place locally, the scope of the law will extend to processing activities that take place outside China under circumstances mimicking the GDPR, say, for example, when offering services to individuals inside China to analyze the behavior of individuals inside China. And more than that, the long arm can further extend as prescribed by the law, rules, and regulations. Will you please click on? Click, please. Yes. I think the problem now is when there are a lot of areas which is still unclear at the moment. And while we're waiting for more guidance from the CAC, there are a few concerns. First of all, what does it mean by analyze and assess the behavior of a natural person? Click, please. And it is important that we understand the meaning of these wordings and what is the scope, so as to formulate our compliance strategies and steps. And also the long arm that further extend by laws and regulations can be quite concerning as well. Click, please. And the difficulty now here is because it seems that the catch-all provision, which as we can see and observe under the PIPL Article 3, can be extended at any time by law and regulations. That can be quite cumbersome and also typical for organizations when it comes to designing compliance. Further, next slide, please. Now, as mentioned before, the extraterritoriality of the law in data protection legislation is not easy to understand, and the scope is actually highly uncertain. It may be a good reference point to look at some of the cases in the EU and also UK. And in the interest of time, I try to explain a bit about this particular case by the UK High Court. And to demonstrate, it is actually highly uncertain. And when you look at this case, you can see that even the EDPB guidance published on the application of the law and the extraterritoriality, it is still not yet definitive, is actually non-binding. What's interesting and the key points that we need to remember when we face this sort of extraterritorial application of the law, we have to understand that the mere presence of an EU employee or agent is not sufficient to trigger the application of the GDPR, so long as the relevant processing is not being carried out in the context of the activities of the EU-based employee. The second point is, in relation to the processing activities relate to the offer of services, Article 3.2 is only aimed at activities which intentionally target individuals in the EU rather than an inadvertent or incidental activities. Now, bearing these two key points in mind, when you look at the case, is actually we can see how the court tried to analyze the case based on these very key concepts. This case is about Mr. Soriano, an individual that holds dual British and Israeli citizenship, and he resides in UK, and the defendant is a news website based in California. And the plaintiff complains about 10 posts containing allegations about himself and about his political connections and financial affairs. Well, the significance and the points about this case is, I think is a useful guidance on what is not enough to trigger the extraterritorial scope of the GDPR. It is also important to bear in mind that this is a case about service outside jurisdiction, and the threshold is just a good arguable case. What it means is there may be further changes afterwards, and it's not definitive. The judge in this case concluded that there's no arguable case and the case was struck out, but it illustrates the unresolved nature of the jurisdiction claims under the GDPR. So when it comes to the establishment test, that is the Article 3.1 of the GDPR, clearly because the defendant was a US resident and the company was not established in the UK for GDPR purposes, the publication of these articles cannot be caught. And also there must be a real and effective activities exercised through stable arrangements. Now the next point we have already touched point, but the judge seems to suggest that the absence of employees or representatives is obviously related to the consideration of whether an organization exists for the purpose of Article 3. When it comes to the long arm of the GDPR, it is interesting to note that the plaintiff in this case actually argue along the examples and the interpretation of the long arm as cited in the EDPP guidelines. He claims that the website is offered in English, and it also can offer the payment by way of pounds and also the euro. And also it tracks the activities of the browsing activities through the website by way of cookies. But eventually, all these was not considered as the key point in considering whether the long arm of the jurisdiction applied. When it goes to the decision, is actually the court comment that although one of the sites offer to ship merchandise to the UK, and this may have happened on one occasion, this fact alone did not qualify as it targeting the UK with goods or services. And it is also interesting to note that a data controller may be subject to the GDPR in respect of some of its processing activities, but not others. Hence, the offer of goods and services was not related to journalism. And it's actually quite important that we have to focus on what kind of data processing activities when it comes to the analysis. And also, finally, it's quite interesting to note that the defendant's use of cookies to inform advertising notice was not related to monitoring a complaint and the substance of the complaint. I think this case illustrates quite nicely the uncertainty of the application of the GDPR extraterritoriality. But there are a couple of messages that we can bring out from this case. Firstly, the policy intent is to give extraterritoriality to the extent that is appropriate to protection of personal data by references to specific processing activities being offered by the entity, and hence the long arm kicks in. And secondly, on a practical level, just because an organization located outside certain jurisdiction is caught with respect to the processing of certain data sets does not mean that the entire organization and all the data sets are also subject to the data protection legislation. It is to be noted that whether parties, and before I jump to the next slide, I also wish to mention that other than the jurisdiction and long arm that under Article 3, we need to bear in mind that in commercial world, a lot of time when it comes to sub-processing and also commercial contract, there would be a legal obligation to flow down the contractual obligation to the downstream, and also outsourcing contract. And it's actually advisable to keep the applicable data protection legislation more flexible when it comes to the definition of data protection legislation, depending on the processing activities in question. Next slide, please. In the interest of time, I won't go in detail of this slide, but since we're in Hong Kong, it would be good to mention as well the legal position under the PDPO. Recently, there is a case on the application of the PDPO, whether there is extraterritorial effect. And if you go through this case, it's actually a Google case Hong Kong version, and it's common that the Administrative Appeals Board rejected the PDPO, rejected appeal, and decided that the PDPO does not have extraterritorial application. And actually the key is that the data user that is in control of the collection, processing, and use of data is not in Hong Kong in this particular case. And that's why that's the reason due to the explicit provision under the law that the Administrative Appeals Board come to this conclusion. And recently there is also an amendment bill published in a couple of weeks ago on the doxing amendment, and the extraterritoriality only restrict to the Commissioner power to serve secession notice concerning the new offense to demand cessation of doxing content, even though the service provider of the platform is outside Hong Kong. So next slide, please. I won't jump into this slide in greater detail because I think Yan has already gone through a lot of these. Just to mention that if you compare the PIPL cross-border mechanism and provision with the GDPR, you can see that the grounds of allow the transfer and also the detail mechanism is comparatively more restrictive, and is also the PIPL mechanism actually overhauls the personal information export control regime under the PI specification, which is effective in April 2020 as well. And also it's also not the same as the draft measure on security assessment of personal data, personal information export 2019. Next slide, please. This slide gives you a comparison between the three different legal instruments on protection of personal information. And when you have time, you can take a look at those. And in the interest of time, I won't jump into great detail, but I just wish to focus to point out that please click on the transfer assessment mechanism under PIPL, GDPR, and PDPO are quite different in a way that PIPL focus more on the security assessment, and then being in some circumstances depend on the nature of the operators whether you need to go to the relevant department for approval, etc. And the GDPR is more like, there is another ground for where it allows the transfer to whitelist jurisdiction, and the EEC Commission will look at the regime of the recipient jurisdiction to and comment on the adequacy of the legal regime. So this slide gives you the three comparison of the data protection framework, so to speak. And when it comes to the exemptions, you can see that actually the PIPL offers a rather restrictive exemption provision because it can only be prescribed by the law and also the regulations. But when it comes to the GDPR and the PTPO, there is actually quite an explicit and extensive provision on the derogation part as well. Before leaving to the next slide, I just wish to add that the separate consent provision also caused a lot of concern for multinational company. The reason for that is because of notice requirement is rather stringent. It requires the organization to provide notice on the identity and contact information of the overseas recipient party, apart from the purpose, method, and type of processing and the type of personal information, etc. So when it comes to multi-layer of transfer and onshore provision of the data to your contractor, all sort of this sort of complicated circumstances, it can be quite cumbersome and also very difficult to comply. Next slide, please. Here, I think it would be interesting to mention that there are provisions in the PIPL that counter the long arm of overseas data protection legislation under the PIPL. It is important to note that for China operation, now we have this PIPL Article 41, which restricts the export of personal data to overseas judicial body and law enforcement agency. And of course, this provision also allows the transfer when it comes to this sort of export is permissible under international treaties or agreements. Actually, if there is a breach of these legal provision, there it's not just the organization that's going to face sanctions. The officer in charge may have to face sanction as well. And before leaving to the next slide, I would like to mention that the security assessment, when it comes to cross-border data transfer, we also can observe that it not only we can find it in the cross-border data transfer mechanism that we see that this sort of mechanism, and we can also see that there are other requirements in other data-related legislation, such as the cyber security review measures that require security review when it goes to outsourcing and also in other circumstances as well. So next slide, please. It is important and eye-catching to wait until to see whether the further CAC guidance, when it comes along, whether it will incorporate the recent EDPP guidelines on the transfer impact assessment, and also the SEC when it comes to the drafting of CAC own guidance and recommended set of standard contractual terms for organization. Now, I come to my final slide just to give you a very high level context of why this is so complicated when it comes to actual operation. When it goes, a lot of times when multinational company operate different jurisdictions, clicks on please, it will be involving provision of services and products when it comes to an offshore circumstances. And then it may be if you set up an office inside China, click on please, then you will find that eventually you may have to collect some sort of personal information, especially when it comes to the employee personal data. Click on please. And then not to speak about the other transfer between your group as well. Click on, please. So I just wish to leave you with one concept of data management and governance. So in preparation for a lot of these, complicated compliance regime, it is important that organization engage in data management governance work. And it is actually a concept concerning the capabilities that an organization should embed to ensure that they understand what data they have, how the data flows throughout the organization, and how we ensure the data is fit for purpose. I think lastly, it will be good to know that there would be requirements to require appointment of data protection professional and to be stationed in the for the compliance work inside China, and that role would be to help organization to drive all these compliance strategy. So lastly, I just leave you with this comment. So understand the law is just the beginning. Compliance is the hard part. Thank you so much. I'll give it back to you, Jane. Angela.
Yes, thank you very much. Shelby, would you exit the screen? Thank you. Thank you, Yan, and thank you, Sandra, for a very informative presentation. And I would like to take the privilege as the moderator to ask a few questions before I open it up for Q&A. And at this point, if you have further questions, feel free to leave it in the Q&A box. First of all, I would like to ask Yan about the distinction between personal information and data. Obviously, we have different laws that govern each of them. And some of the Chinese academics actually distinguish them and saying that data is more related to property rights, whereas personal information is more related to civil rights. And I also saw through your presentation that there seems to be quite different implications when this is deemed a data or personal information. But in practice, I guess there will be overlap. And how do you decide, how do you decide which one to fit in what box? How does it affect your practice? I mean, the distinction between the two.
Right, this is a great question, and I have to say that we sometimes in practice use them more interchangeably in terms of data and personal information and personal data and non-personal data. So there's a lot of variety of of terms that could come to here. So I just wanted to mention that there's some legal definition here on data, which is the data security law states on the Article 3 that any information recorded in electronic forms or other forms will be called as data under this law, right? So this is much broader than we thought of data in Europe or in the US. For most circumstance, this is sort of all encompassing of all forms of electronic or even non-electronic records of information. So that's the legal definition here. And personal information in China is quite similar as under GDPR, where you have identified and identifiable data, identifiable information that is related to a personal nature person, and that's sort of the personal information. I don't have the precise definition in front of me on personal information, but that's I would say in practice where we use it interchangeably with personal data under GDPR, at least the way we think about it. And in terms of data security law, we tend to think that's include both personal and non-personal data. And that's the way we think about it. Obviously, the question about whether there's any difference between information versus data, it's a good question. I don't believe there's any settled, like, it's a sort of settled question here. We'll continue to see that the boundaries might be sort of pushed on one side or the other. But in terms of, making sure that companies understand the big bucket obligations, we still think that data security law covers both personal data and non-personal data, and then personal information / personal data will be identified or identifiable data. So that's the way we sort of conceptualize them. Yeah.
Right. Thank you, Yan. I mean, that's very, very helpful. Because I did struggle a lot when I tried to understand these different types of law and different requirements. And Sandra, if I may turn to you, as you did mention the CAC's new measures on cybersecurity, and that was the draft was issued after the whole DD debacle, and it seems to target at those online listings. I used to practice antitrust law, and I remember during my practice that there have been a lot of information requests from the regulators overseas. I remember in one instance, one of my Chinese state-owned clients need to make an acquisition in Europe, and they need to submit tons of information to the European Commission, right? I mean, there wasn't such a strict regulation at that point, but I did remember my client was concerned about data privacy issues. Now, the cybersecurity review measures recently promulgated was mostly talking about information transfer over this kind of listing transactions. But there are so many other circumstances like this antitrust review or foreign investment review, or or a typical discovery process relating to litigation we can imagine that involve a lot of cross-border data. So how do companies comply with this requirement? Because this seems to be kind of like, it's not like the listing, a company only need to do once or twice, but this kind of M&A and this is very routine matters that happen every day almost. How do you advise companies to comply with those obligations with all this kind of almost routine data transfer problems?
Thank you for the question. I think it's a very valid one and also a very good one. Actually, I feel that this is a multi-dollar question as well. I mean, when facing this sort of new requirements and also uncertainty, I have to say that the threshold triggering a lot of these requirements are not very clear at the moment. Say, for example, when it comes to seeking approval, when you try to export the data outside China to meet the law enforcement agency request and also judicial body request, what will be the approval criteria and also consideration is actually not very clear at the moment. It's also quite, concerning from a compliance perspective, because when you look at the processing ground under the PIPL, it does not touch upon the processing ground that based on legitimate interest, and also the exemption provision is not as wide as compared with the other data protection law, such as the GDPR and also even the Hong Kong data protection legislation. For, say, for example, for investigation of crime and for prevention of serious improper conduct and things like that, under the PIPL, the broad provision is the grounds that allow the processing as provided under the law and also the regulation as well. I guess in future there would, for compliance work, it is very likely that we have to deep dive into the legal provisions in the mainland world when it comes to whether particular processing is permissible under the other legal regulations and specific law as well. So to give compliance more comfort when it comes to export and also a processing ground. So I guess it would be good for all of us to monitor the further development, and especially when it comes to the CAC guidance and also the other piece as well. We do understand that there may be, there are lots of concern, especially when it comes to the security review and also approval. Should it be per transfer or should it be business operation, based on business operation? So I think there are lots of questions here, and it will be important for all of us to just to monitor the development and see how the further guidance from the authority.
Right. I mean, this is really good. And I wonder, I mean, I wonder about very, very practical question here, because one of the impression that I got from this presentation is that there remains a lot of ambiguities with the current law. There's a lot of holes that need to be filled as things develop very quickly, and the circumstances are very fluid. Now, how do you, I mean, either one of you can weigh in. How do you advise the client in this time of uncertainty? Especially we have kind of a quite fragmented framework of enforcement, whereas you have simultaneously many different regulators from the central and the local level, even though you have the CAC at the top as a coordinator, but there's such a patchwork of regulators here governing the cyberspace. What do you do about with all this ambiguity? Do you just talk to CAC, or do you have to approach all of these relevant actors to understand and kind of, you know, at least give some guidance to your clients what to proceed? Anyway, either one of you would like to weigh in.
Maybe I just comment on from an in-house perspective. I think it's very difficult to tackle the question, you know, on the specific law. But I feel that it would be good to, you know, to look at the data governance and also the data policy and practice within the organization first to start with, because if you understand your data, understand the process, and understand the grounds of processing, the source, etc., is actually much easier when it comes to compliance. But understanding classification, purpose, mapping, all of these activities is actually a very, very complicated task, and it can be quite exhausting. A lot of time when it comes to engaging with, say, for example, external help, my personal observation is it is not the end of the matter, even though you try to ask somebody else to, externally, to seek external help. You have to provide the information for whatever consultant that you engage. So I think it's inevitable that you have to understand internally the policy, practice, your data source, the use, the flow of the data, and in multiple jurisdictions, etc. To start with, that's my observation.
Yeah, would you?
Sure, I'm happy to quickly. I think what Sandra has really nailed it is that understanding your data, understanding where the risk comes from, and also, you know, try to understand to the extent possible of the regulator. I think that's probably all we can say right now. There are certain sort of lower hanging fruits on the compliance tasks that companies should do and across the globe that they should consider to sort of safeguard your network and make sure that you're processing data on a solid legal grounds and stuff like that. Is really any company should consider those those compliance steps to be taken in any any one of the jurisdictions that they operate, right? So it's not something that they should, China is probably no different in those respects. I mean, there could be certain uncertainties in some of those, compliance requirements, but in any way, we feel like, a lot of clients say to us, for example, we're GDPR compliant, or we tried our best to be GDPR compliant. What else do we need to do, right? So it probably already done 70% of the work, but there's a few things, for example, considering potential Chinese national security risks is something that companies will have to navigate in this uncertain environment. It just, there's a lot of the transfers that is happening every day. I mean, I saw some of the questions from the audience as well. So there's a lot of transfers happening, and which was not regulated in the past. And will they be regulated in the future? Maybe or maybe not. But companies will probably have to be more proactive in thinking of those risks, a little bit more in China. It's the ideal world is that we all have the clear guidance and we operate. It's just not the time we're living, especially if you consider all the geopolitical risks and so on and so forth. So unfortunately, that's probably all we can say now.
Right, thank you so much. Now I will leave the rest of the time for our public Q&A. And I did saw a very interesting question from a financial regulator in Hong Kong. And he or she spoke about the experience when they request an investment fund related data from mainland financial institutions regularly, but one of them refused to submit the data to them for reason of data security. Well, first of all, I mean, I'm struck by this question. I thought Hong Kong is part of China, so there shouldn't be any national security concern. I'm curious. I mean, what do you make of this case? I mean, is there any justifiable extraterritorial legal implications here? Either one of you would like to weigh in?
I'm happy to, a few very quick thoughts here. So any data leaving mainland China is probably of a concern. So a lot of the, and companies in China are considering, even the Chinese companies are considering of, how much data they transfer out of China or submitted to, foreign or quote unquote, the authorities in other jurisdictions. So they're considering those risks. Whether that will be having a solution that's potentially could have solution on a regulator to regulator base. That's something is open for discussion, I guess. So it's probably for companies, they are harder to evaluate the risk right now. So it's probably sometimes it's probably a better solution will be regulator to regulators conversation. Yeah.
So do I understand correctly that that applies to data leaving outside of mainland? Then that provision of overseas regulator include Hong Kong?
It's very hard to say. There's no clear guidance that, but a lot of times that it's not entirely clear how that views. We'll have to wait for further guidance. But any data leaving mainland China is potentially of concern to companies. Yeah.
I see. Sandra, you want to jump in or?
I feel that I do agree with Yan that a lot of times, and when it comes to this sort of circumstance, that it would be good to resolve it at a level between regulators. I do feel that there are a lot of misunderstanding and a lot of loopholes currently, and it would be good for different parties to negotiate and try to assess whether and how these sort of requirements applies to them. I think that even when it comes to a lot of these security assessment and cross-border transfer restriction, what can that be solved by way of technical, technical measures? I think it would be the discussion between the parties, one of the directions for them to resolve. Because a lot of times when it comes to cross-border data transfer restriction and also localization requirements, the driver behind this, the so-called concern that actually when it transfer data outside certain jurisdiction, it will be outside the scope of reach of the regulators, and then it cannot be, they cannot exercise oversight through these sort of data if it leaves the jurisdiction. Try to understand the reason behind for this sort of concern and whether they can be addressed, and also in light of the further development of the law and guidance. I think that's something we can focus on, with this particular question.
Right, I mean, that's very good. Now let's move on to another question from our audience, Livy Martin Wang. He mentioned that there have been some local data regulation. It's kind of like experiments, I believe, that some cities in China, I remember both Shenzhen and Shanghai, have their own data law, data regulations. And his question is, how do these local regulations fit in before and after the personal information protection law is enacted? Either of you have any comments on that? Yan?
I'm not sure I have much comments here. So, we noticed that there's some local regulations, and it's harder for us to. This is probably a question for Professor Xu. He's probably more of an expert on this. So we don't really see any impact in practical terms, at least as of yet. Because most of our clients operate obviously across China, right? So it's really not going to be said that they are bound by one local regulation. So we haven't really seen much of the practical implications yet. And as part of the Chinese legal system hierarchy, I mean, local regulations shouldn't be in conflict with national laws, and that's just a general principle. So we hope there's no conflict moving forward. But it's locally they probably can provide more incentives or some other rules. But generally we still hope that the national laws will be applied even-handedly across China, because that will be, otherwise it will add another level of complexity in terms how companies can comply and face the challenges.
Yeah, great. I mean, I thought those local regulations are designed as experiments to push through some potential legal changes, and I have heard some criticisms about those local legislations being a bit too ambitious. Now let's move on probably to one last question today, because we're slightly over time right now. It's about enforcement, right? I mean, there's one attendee raised the question of how do the Chinese government enforce the law if my business have no presence in China at all? I mean, we talk about the long-arm jurisdictions, but how practically can they really enforce against us?
Well, just to simply point out that I think that's always a valid question, but I mean, when it comes to enforcement and also the impact on the organization, I think it's always good to consider not just the technical side, but also the reputational side as well. Because when when it comes to enforcement, the announcement by the regulators, and afterwards, when it comes to your income source and etc., business prospect, it can be huge and significant as compared with the technical side. It will be good if you have any doubts that these laws apply to you, then you look at the legal requirements and try to assess the legal obligations and try to ensure and incorporate compliance obligation and steps as well.
Right. I mean, thank you, Sandra. Thank you, Yan, for the very insightful comments. And both me and the audience asked you very tough questions in the past 30 minutes. And your presentation are wonderful. Given how fluid the developments have been, this is extremely helpful and valuable insights that you have given us. We have recorded the session of today's talk, and we'll be able to send the recording to all the participants afterwards. This is the second seminar in this webinar series, and our last webinar on personal information protection law will be on the internet platforms, and particularly on the privacy obligations that large internet platforms, those gatekeepers, potentially need to shoulder. And I very much look forward to hosting the next webinar, and at the same time really thank both Sandra